board meeting by phone, I think in September or October. We incorporated August 10th, 1992 in the District of Columbia.
Yeah.
And we had our first formal board meeting, approved our bylaws, then we immediately expanded the board. And we started making plans to have our first convention the following August. And Norma agreed to do the legwork and putting that program together, arranging with the hotel.
No, actually I didn't.
Who did it then?
Suzanne did it.
Okay.
That's what caused me
Suzanne
to...
Bingham.
Yeah. Wait, that's... I looked at what she was doing and I said, I think I'm going to do this one next time.
So we strategically planned to have our meeting just before the annual
Yeah.
conference of the NACTT, because
Mhm.
we knew we thought we could get a lot more people to come and have one trip, go to 2 conferences, and find a natural home in NACBA. And when we did that, we found that the then leadership of the NACTT,
They weren't too excited
they
about
were
us being
very
there.
unhappy that we were doing this. They didn't at the time, and they later changed their minds.
Yeah, they became very
Didn't feel the
supportive later.
need for a group like this, and thought that somehow this
We
was
were
going to be,
encroaching on their territory.
or that we'd advocate against their interests or whatever. Things that, within a few years, the people that had that view joined NACBA. But at first, we had that conference.
So that was actually the first time that we all, as board members, met each other, because we had transacted business by phone.
And this would have been August '93 in DC?
Yeah.
No, we had it
in,
at the Grove Park Inn in Asheville,
Asheville,
North
North
Oh,
Carolina.
okay, I'm glad you
Which is where-
asked you that.
NACTT had their site,
Okay.
so we picked that site.
And you had it before or after their meeting?
Before. And we invited, and we're fortunate to get recently retired at that time Judge Ralph Kelly from
Mhm.
Tennessee.
From Chattanooga.
And I will just say,
And Pam Banks came.
Pam Banks from Metzenbaum's staff came, and
Right.
we had a very nice short day-and-a-half program. We had about 73
Mhm.
attendees, and considered it a big success
Oh, yeah.
to have that. And I wanted to say about Judge Kelly, throughout our history, we've been blessed that we've always had very good support from the bench. Whenever we've had conferences, we've had very willing and enthusiastic willingness to speak at our conferences on various topics. And we've had a number of judges be the keynote speakers over the years. And
Including yourself.
It started with Ralph Kelly that year.
Mhm.
And that helped to give us some credibility and visibility beyond those that had come to know us.
And so just for the record, when we incorporated, this was part of my job, was, the incorporation. And I did the 501c6, we're 501c6 business league.
Which allows you to advocate
Yes,
in line.
yes. So I did that application and we got that authorization as well as the
Okay.
various state.
So you had about 73 people, and I assume that membership just grew by accretion, that the more people had heard
Well,
about it.
That was part of our growing pains, and there were like certain spurts.
Okay, yeah, but I'm the one that did that, so let me tell you what I did.
Okay.
So again, this is before the internet.
Right.
Jim and I had just signed up for, what was it? What was it at the time? LexisNexis now, but the equivalent of that at the time, internet access to case law. And they also had an attorney's directory. And so, but the usage fees were pretty high, but because we just joined, we had free usage for like 3 months. We ran that thing so hard. If we had to pay for it, it would have been over $17,000. So what I did was that I used it to pick up bankruptcy attorneys throughout the country.
Uh-huh.
So it was a very, very grunt work oriented thing, but my secretary helped me on it. We were accumulating a list of prospective members. And then at the same time, we were looking to try to see about possibly doing an attorney's fee increase in the San Jose area, in the Northern District or whatever.
This is for Chapter 13.
For Chapter
Right.
13.
Fees.
And so I wanted to do a fee survey nationwide. And so we had the names of the Chapter 13 trustees. So, and I don't know I don't think I had started that when you went to Palm Springs yet. But
It was at the same time we
It
were
was
doing, it
right
was during that
about
summer,
that time.
we sent out the survey.
So I faxed, because fax was a new thing then. That was great. So my secretary and I faxed out a survey questionnaire to all the Chapter 13 trustees about what the fees were, if there were no-look fees, quote unquote, and what the
And a no-work fee refers to not having to prepare timesheets, but rather just charging a flat fee, and if you did the work, that was the end of the story.
Right, and what the conditions of that were, et cetera, pretty detailed survey. And the Chapter 13 trustees were very interested in helping because they wanted to find out as well. So this is the first nationwide survey on it.
Mm-hmm.
But one of the questions was to the Chapter 13 trustees was, who are, like the 5 most active attorneys in your area? So we put together a whole list, and we were just faxing out information about the NACBA, and asking them to join, and that did produce quite a few members.
So how many did you have by the time of your next conference as members?
Our membership was,
one, or?
So the first one was 73.
well, that wasn't
No,
our
that was
membership,
just- that was just the people who
attendees. Our-
attended.
Our
Just
membership by then was probably about
Couple
150.
hundred.
Oh, I
Yeah.
see, okay,
Yeah.
right, of course.
One of
Yeah.
the other drivers, our first full year of '93, was a very significant case came down in California called In re Pladsen. And the Pladsen case involved a Chapter 7 case where a trustee had challenged a bankruptcy debtor's right to use the California homestead exemption. And the lawyer lost at the bankruptcy court level, the creditor or the trustee's lawyer, but he didn't take it up to the BAP. He went to the district court, and one of the judges in San Francisco decided, debtors don't
Von
get,
Walker.
they don't
you know.
get the homestead exemption.
And why was it that this was being challenged? I mean, what were the circumstances?
Well, the
And the name of the case is Pladson?
S-O-N.
Is it S-O-N?
S-O-N.
Okay. They found that, I think it was because they said a bankruptcy wasn't the equivalent.
Well, they said
Of
that
a-
the state exemption, the state homestead exemption, was only applicable as a defense against a money judgment, and that the filing of a bankruptcy was not that, and therefore you couldn't use it.
Even though historically, the bankruptcy courts treated the trustee as in the shoes of creditors that could liquidate assets. And so that case presented a huge problem to all the lawyers in California immediately. So we did a couple of things. One, we organized around that case, and we sent all the lawyers that we had on our database in California, this case is out there, we're working against it. NACBA hired a lawyer.
No, we didn't hire a lawyer.
Yeah,
Gary Garfinkel? We
yeah.
didn't pay him a darn thing.
No, but we hired.
Oh, okay. We did things for free, man.
Yeah, but we retained a lawyer
yeah.
who was willing to go
Yeah.
and take that case up for us to the.
Yeah, he was
circuit.
great. He did a very good job on
Simultaneously, we
the.
went to Sacramento, and with the aid of a state senator from San Francisco named Quentin Kopp, who was neither Democrat or Republican, but an independent.
And there was a reason for that, because things were so log jammed there between the Democrats and the Republicans. Neither one could get anything passed. So we figured, go for an independent. Maybe we'll have a chance of getting
He
it
took
passed.
an interest in
and
this
he
issue.
said, sure.
And he said, let me help you with this. And he got through emergency legislation that corrected that finding. Simultaneously, the appeal went up, and about a year later, the district court was overturned and the homestead was
Right.
confirmed both ways. That Pladsen case served as an organizing.
Right.
For lawyers in California.
Yeah,
So
it was
lawyers in
actually,
California.
it was close to a miracle, because the Pladsen decision came down in the spring, I think it was in May. And so we, by the time we connected with Quentin Kopp's office, which is immediately, there was very little time to get this thing enacted. So he gutted another bill that had gone through the state Senate already and put our stuff in it, and we got the thing through with 2/3 vote for an urgency clause in it, which meant it would go into effect immediately.
Mhm.
And we got it through and signed by the judge in like 3 months.
By the governor.
I mean, the governor,
Mhm.
3 months. So that was like kind of
Well,
a miracle.
I think it didn't help us just in California, but the fact that NACBA was going to play that kind of a role
Yeah.
was attractive to lawyers
Right.
around the country.
Yeah.
Because they were going to need this at some point, maybe.
So by the time your second conference comes around, where was your second conference?
Second conference was here in San Francisco in 1994, a few
And-
blocks from here.
Right, in the Fair, was it at the Fairmont?
No, it was
St.
at
Francis.
Yeah.
St. Francis.
Right.
And by that time, how many members did you have?
I'd say probably in 94, we probably had 250 to 300 members. And
Just-
we had an attendance, our attendance went from 73 to 105. So we thought that was a good,
Mhm.
105 people, that was a
Mhm.
big
Yeah,
turnout
it was
here.
big for us.
And who were the academics, if any, that you work with and who supported NACBA's work? We mentioned Henry Sommer, who is now, of course, one of the editors and co-editor-in-chief of Collier.
Yes.
Certainly qualifies as an academic. Who else was involved with you? Did Elizabeth Warren, for example?
Not at that point, not early on. Later, yes,
After
definitely.
we got to know her at the Review Commission, the National
Right.
Bankruptcy
Yeah.
Review Commission, a few years later.
Any other academics you can think of? That were,
Not really overtly. Later on, we had support from Professor Gary
Gary
Neustaedter at
Neustaedter
the University
helped
of
a
Santa
little bit.
Clara Law School, helped us over.
Right.
And more recently, Jean Braucher, professor at the University of
Yeah.
And how do you spell her name?
Braucher. And Jean, who recently passed away, ended up becoming a board member for NACBA, probably
Mhm.
one of the academics that we had, and played an important role during her time with us.
Mhm.
Any other academics you can think of that were here from the get-go?
Mm-mm.
Okay. This might be a good time. We've been in session about an hour. Would you like to take a break, or would you like to continue on?
Doesn't matter.
Well, okay,
We
let's.
can continue.
Okay, fine.
Mhm.
Now, to what extent did NACBA get involved in the legislative debates leading up to the 94 amendments to the Bankruptcy Code and the formation of the Commission? You've already indicated that you were very much involved in the lead up to the 94 amendments, which frankly didn't amount to a whole lot at the end of the day.
I don't
except
know,
for the-
they
except
were
for the
pretty good.
commission.
Well, there were
Oh, no, there were some good things.
there were some things that came in there
Yeah.
that we kind of felt like we snuck in. It didn't have visibility, which probably helped us get these things
Right.
accomplished.
Yeah.
And by then, we made our first Washington, D.C. lobbying trip in September of '93, a month after our first convention. Jeff Friedman, Elizabeth Peterson, and I went to Washington, and we had Suzanne Bingham set up as many meetings as she could cram in a day and a half, because we didn't have a lot of money, so we can't stay here long. And get everything set up that you can.
Yep.
Turned out she set up 16 meetings for us in a day and a half.
Uh-huh.
And the three of us trekked through the Senate and the House sides, meeting with primarily senior judiciary folks. And we were working on these same bills that I mentioned earlier, that Heflin still had these proposals out there. But we came forward with some of our ideas that we wanted to have. We thought that one of the things that we thought was a dire need was to increase the debt limit for Chapter 13 cases, which at the time I think was $100,000 for unsecured
Yeah, it
debt
could've been.
and
Something like
$350
that.
for secured debt.
Or
The
$250
mortgage
or
debts by
something
then
like
were, it was very low.
Yeah.
Disqualified a whole lot of
In
consumers.
California, that would have been more
Yes.
than adequate in
Yes.
places like Ohio.
Yeah,
Yes.
that's very true.
So that was one of the changes that we thought. Also, there had
Well-
been some adverse court cases that had come down at the Supreme Court.
Also, the inflationary adjustment.
Yes,
For.
I'll get to that, too.
Okay, all right.
There was one case that came down called Rake versus Wade. And Rake versus Wade dealt with the issue of
Supreme
whether-
Court case,
Yes.
RAKE versus WADE.
And that case had come down adversely and said basically that mortgage lenders could would be entitled to present value of money on their arrears in a bankruptcy, even if their contract didn't provide for that.
Mhm.
So we got through an amendment to 11 U.S.C. 1322, I think C,
Mhm.
which reversed that and said it's subject to what the applicable non-bankruptcy law was. So we got that provision put forward. We got a provision that you worked on about, I think in 94, where if a debtor converted from Chapter 13 to Chapter
Yeah.
7, after they had satisfied a secured claim, say they had a car loan, and it was secured value was paid, but then the debtor had to convert, the debtor, by having satisfied it during the 13, would be entitled to get the title certificate
Rather than
after
having
the
to
7.
charge them all from square one again.
So, and then finally, we talked to Don Edwards specifically about this provision, is we needed to get some inflation adjustment to affect these numbers going forward, so we wouldn't constantly be lagging behind. So Don Edwards, Jack Brooks. Jack Brooks was then chair of Judiciary, and that was the last year that
Was Jack Brooks from Indiana?
he was from Texas.
Texas, that's right.
And with Don as one of the senior Democrats and Jack Brooks there. And their general counsel was a fellow named Jonathan Urowski. And they were very helpful in going to Senator Heflin, who still had ruled the roost on the Senate Judiciary Committee, and getting Heflin to accept these consumer-friendly amendments in the 94 bill that passed. As far as the commission itself, we didn't really play a role in that.
Right.
We didn't lobby for or against it. It really didn't sneak up much on our radar, and I don't think we really understood well at that moment what the purposes some advocates had for that commission.
Yeah. I want to go back and touch on two more points, two more things that the 94 Act included. One was, that was written by Henry, was a very good,
Summer.
very good formula for calculating when a judicial lien should be avoided under 522F. There had been a few cases that had come down that had muddied the water and made it really difficult to achieve a just result there. So he basically wrote out the formula for it, which has, I think, been very good. That was very important. And the other thing, which I was involved in, is what's now Section 110, the bankruptcy petition preparers provisions. And this might not be something that you know, I'm not sure, that when the bill was first introduced, the petition preparers, or the non-attorney paralegals, actually had the opposite of almost all of those provisions in it, that it would allow them to do all of those things. They could do everything. So,
They were organized as well, weren't they?
yeah, they were. And so I read that and I thought, what the heck? You know, this is not going to be good. So I talked with Pam Banks about it, and I said, this was in 92, this was right at the beginning. And I said, well, she said, well, you know, rewrite what you think we should have in it. So I said, well, we'll start right now in an emergency thing by putting no in front. You can't do this stuff, the stuff that they said they could do. So we put a lot of no's in there, can't do that. But then as it progressed in the next year or so, we put a lot of, you know, penalties, and, you know, we really kind of fleshed it out. So
It's worth putting a context of what this was really addressing. Because of the recession in the early 90s, there was a huge growth of non-lawyers holding themselves out as petition preparers and preparing bankruptcy schedules, which in many cases were terrible. In many cases against the interest of debtors. Sometimes debtors weren't getting discharges, or they were filing petitions for debts that were not dischargeable.
Sometimes debtors didn't even authorize them to file.
Sometimes they
cases.
didn't sign them.
yeah.
It was like a wild west of abuse, and it was quickly clogging up the entire bankruptcy system with sewage, frankly. So there was a real need to have some kind of mechanism to police this. And so Section 110, which Norma worked on with Senator Metzenbaum's office, became a tool that later the U.S. trustee program could use to clamp down on these abusive folks. I mean, yes, it has an element of self-interest where lawyers would want people, non-lawyers, doing this, but the reality was they weren't doing real bankruptcy.
Well, I mean, we could see the damage
damage.
that was being done to real people.
And we got a lot of support for that from many groups who
Right.
didn't want that bankruptcy to become that.
Now, to what extent did you participate, now that the commission, Mike Sinar ended up being the initial chairman of the commission, and there was kind of a motley crew of other commissioners, as you'll recall. But what role did NACBA play as the commission hearings proceeded?
I think we played a very prominent role. I was president of NACBA from our founding in '92 through '96, and Norma followed me from '97 through early 2001. So we bridged that time. We were invited as the only consumer bankruptcy group to the initial meeting they had, I think, in April of '95, just sort of like a get-to-know-you group. And at that meeting, we met this cast of characters, and Norma and I were there, as well as Gary Klein. So they had debtor representatives there. They had a lot of credit industry lobbyists there, trustees, some judges. And shortly thereafter, 2 months later, Elizabeth Warren, who had been hired from Harvard to serve as the reporter for the National Bankruptcy Review Commission by Mike Sinar. Mike Sinar ended up getting brain cancer during this period of time, and he died like within 6 months. And President Clinton appointed Brady Williamson from Madison, Wisconsin, to become the new chair of the committee, take that seat. So by June, Elizabeth Warren was convening subgroups, including a consumer bankruptcy working group. And on that group, she had Judge Edith Jones from the Fifth Circuit, and she had a business lawyer from the New York area whose name is I'm not getting, and Judge Ginsburg from Chicago, Judge
Robert.
Bob Ginsburg.
Yeah,
Yes.
he was a great guy.
So they were the consumer group, and I was invited to the June session there. And
This would have been June of
'95.
5.
And it became clear that Professor Warren had kind of a different approach than I think many of us in NACBA did, as what needed to be changed in the bankruptcy laws. And I think she and a number of colleagues, and many of them in the academic world, believed that maybe a one chapter approach where it would become more of an administrative vehicle, wouldn't be really an advocacy entity, and people